Now to the currency swap, where the Supreme Court restates its order made on 8th of February restraining the federal government through the CBN from implementing its February the 10th deadline of invalidating the old 200, 500 and 1,000 Naira as legal tender. The court restated this order after it joined 9 states as co-plaintiff in the suit and 2 states as respondents. Judiciary correspondent Celestina Area has details.
The Supreme Court on 8 February halted the federal government through the CBN or any of its financial institutions from stopping the use of the old 200, 500 and 1,000 Naira notes. This order is to subsist pending in hearing of the motion or notice filed by Kogi, Kaduna and Zamfara states challenging the decision of the CBN to stop the use of the old 200, 500 and 1,000 Naira notes by 10th February. The Supreme Court have made an order of interim injunction restraining the federal government through the Central Bank of Nigeria or the commercial banks from suspending or ending on 10th February 2023 the time frame within which the old version of the 200, 500 and 1,000 Naira denomination of the Naira may no longer be a legal tender. The court adjourned to 15th February. At the resumed sitting, 11 other states brought in applications to be joined in the suit. Lagos, Ondo, Ekiti, Katsina, Cross River, Ogun, Sokoto State, Kano, and Niger State sought to be joined as co-plaintiff, while Edo and Bayelsa State sought to be joined in the suit as respondents. The court admitted parties seeking to be joined as either co-plaintiff or respondents in the suit and ordered their existing plaintiffs, which is Kaduna, Kogi and Zamfara State, to amend their processes to reflect the same. Counsel to the state government, Akim Mustafa, drew the attention of the court to the non-compliance of the respondents to the orders of the court. The justices of the Abet Court noted that the order is to subsist pending a hearing of the motion or notice. The 7-member panel led by Justice John Okoro noted that what is most paramount is for the good of the nation without losing facts of the sufferings of the people. He asked the parties to maintain peace and they should return to court on 22nd February to consolidate all applications and hear the substantive matter.
Look, we are working towards solving this problem. It's a national problem and we are working towards solving this problem. There aren't 2 sides. We are affected on both sides. We are trying to solve it. Please, I want you to know the government is not deliberately frustrating the plaintiffs. This is a problem that we are trying to solve. With a little time, it will be solved. Please, I beg you.
We made the point to the court that the court order of 8th of February restraining the defendant is still subsisting, and the court confirmed now, and the implication of that is that the old notes still remain as legal tender in this country. The policy or directive given by the CBN governor becomes inconsequential.
We are in court because Nigerians are suffering as a result of this CBN modeled up cashless versus currency redesign. That is why we are here today, and from the understanding we have from this court, the order made by these honorable justices still subsists up till Wednesday when the matter will be heard.
The CBN had on 14th February announced that the old Naira notes are no longer legal tender. This move by the CBN is contrary to the orders given by the Supreme Court. The Lagos State government in a press release urged Lagosians to desist from rejecting the old Naira note or face prosecution. Celestina Area, TVC News, Abuja.